Good morning, everyone. I'm Michael Miles. To say, listening to Professor Harvey, it almost sounded like FATCA was a really, really good idea. Just to back up and look at it from a kind of a larger perspective, what we have here is the U.S. being concerned that a small number of U.S. citizens are avoiding U.S. tax by investing in foreign accounts, financial accounts of some sort, bank accounts, mutual funds, whatever they may be. And in an effort to catch these folks, what the U.S. does is unilaterally decide that it's going to force every financial institution in the world that invests in the United States to report on these people under penalty of having 30% withholding being imposed on every dollar of earnings that they derive from the U.S. So if you've got a bank with one U.S. citizen who's invested in the bank, that the U.S. is going to take this huge club and beat it over the bank's head in order to force the bank to report on that single U.S. person. And it does this totally on its own, basically ignoring what the rest of the world thinks about any of this. And what we're going to be talking about this morning, at least in part, is what the rest of the world thought about this when it happened, and what the ramifications are, both short-term and long-term. So I guess the first question I've got for the panelists here is, when FATCA came along, and Peter, maybe I'll direct this at you first. When FATCA came along, what did foreign governments, in your case Germany, think about the U.S.'s approach to catch U.S. tax cheats?
Wow, because it was a really impressive step the U.S. has taken, and it was not easy to understand how the market and also the foreign financial institutions can deal with such an impressive new law. But there is a common approach, especially in the countries in Europe and with the US, and that's for us was really important to understand also the political background to this law. There wasn't clear common political approach to combat against tax avoiding. And in the past, that's the true. We saw it too often that a country like the US or other countries like Germany, I can only speak for Germany, please accept that, I can't say anything for another country, that it was not wondering for us, that we could deal with it from a political point of view to see there is a political and a legal need in the US to go this step, but pretty clear was it is a real ambitious law, it is a cost-intensive law, and it is not an easy law because, and the colleague from the Treasury is able to declare much better than I am, you have to deal with such a lot of questions. For example, the definition of financial institution, foreign financial institution, the pass-through payments, all those things are so ambitious that we in the first step say, by God, that's a big step and a big country has done it and we have to deal with it. But it was pretty clear that we have also to see the background beyond this.
And Jim, obviously foreign financial institutions, we're going to have to and had to implement very expensive procedures to implement FATCA. Again, kind of on a worldwide basis, the expectation is FATCA implementation is costing billions of dollars, billions with a B, as every financial institution in the world has to implement procedures to go through its customer base, to change its procedures, to update software, to incur many, many types of costs. And maybe you can just sort of speak to how taxpayers on a worldwide basis have reacted to this.
Well, to correct it, of course, they don't have to do that yet. The regs are not final yet, they're not enforced yet. It seems primarily what is happening is we have two parallel, and of course the topic of this panel is the intergovernmental agreements, as kind of the flagship for addressing those issues. So that on the one hand, we have panicked FFIs going to their governments, looking at these potential costs and say, my God, do something, go talk to the Americans, work something out. On the other hand, and I think in keeping with what Professor Harvey said, a unilateral law by the United States that may be difficult and frankly I think impossible to enforce, both of which point to the direction of saying, well, let's have international agreements initially on a bilateral basis between the United States and other countries, providing for these other governments in effect to be deputized as enforcers of FATCA for the United States. Now, for those institutions in the other countries, it removes the terror of the 30% withholding, but I don't think it's really going to do that much to reduce the cost of compliance. It just changed to whom they're reporting. They report to their own governments for transmission of data to the United States rather than directly to the IRS. It seems to me that foreign institutions and foreign governments have too easily fallen into, maybe trap is too strong of a word, but into an expectation that FATCA is inevitable. We must make the best of it through these intergovernmental agreements. But in effect, what they've done was rescued a regime which would probably not be enforceable on its own. That if government, well, they put it a different way. If another country had passed a law of similar invasiveness and cost on American domestic institutions, I would expect and I would hope that the American corporate and governmental response would be a two-word answer, the second word being you. That, unfortunately, has not been the response from our foreign partners, but rather they've rushed to help fasten these handcuffs on themselves in a way that I think is actually counterproductive for them and for I think, the United States. And I think there are profound domestic consequences to this that haven't even begun to be addressed.
And we'll get into that in a minute, but just to kind of amplify that point. So what you've got is the U.S. imposing this regime, basically saying, if you don't tell us about your U.S. account owners and how much money they're putting into your account, how much money they're pulling out, what their taxpayer identification number is, what their name is, what their address is, give us all this information so that we can go after them in the U.S., we're going to hit you with this 30% withholding. And irrespective of the notion that some reporting already occurred into the existing system, in most countries, reporting this quantum of information with respect to the account owners was contrary to local law. You could not do it. It violated privacy, data protection laws in most countries. And so you had a regime that basically forced financial institutions to say, you're putting us in this terrible place, right? We can't report the information to you because we'll violate local law. In some cases, criminal offenses. Singapore, for example, you report financial information of your account owners, you're subject to caning. So it puts them in a very difficult position because if they don't report, then they're subject to 30% withholding on all their U.S. investments. I think Professor Harvey was exactly right. That the only country in the world that could have done this, that would have had the nerve to try to do this, was the U.S., because if France had done it or Germany had done it, the response would have been, we're just going to pull our money out of that country. We're not going to incur hundreds of millions of dollars expenses or billions of dollars expenses in order to invest in that jurisdiction. We'll just go someplace else. But the U.S., for the time being anyway, kind of a unique place in the world in terms of investment, so it was able to pull this off. The intergovernmental agreements that Jim was referring to earlier, and we'll talk about those in a minute, they are a way to get around, in effect, the local privacy law limitations that apply, because what they do is allow the banks, the funds, the insurance companies in these jurisdictions to report all of this confidential information not to the U.S., but to the local taxing authority. And the local taxing authority then turns around and sends it to the U.S. So it's a way for countries, for financial institutions countries, to comply with FATCA on an indirect basis when they couldn't do it on a direct basis. And it really is the only way that FATCA can be implemented, Jesse, because there is no way that information could have been applied directly without changing the laws, the data protection laws in all these jurisdictions.
Right. This is sort of a heck of a lead-in for the government guy. I think it may be helpful to take at least one small step back first. I think it is clear FATCA was not very popular with the financial community or with foreign governments when it was first passed. Some of that was based on concern over the level of burden we'd be placing on foreign financial institutions to try to ferret out U.S. tax cheats. There was concern that we were going to make people go through their entire book of accounts, search, ask every account holder, are you a U.S. citizen or are you not, and then perform reporting on that basis. And so I want to talk a little about the two separate tracks we've taken to try to address those concerns. Treasury Department and IRS issued a series of notices to try to set out our initial thinking about how compliance under FATCA would work. Because we recognize that when we're imposing these requirements on foreign financial institutions, we need information about how financial institutions work, what type of process is going to be least burdensome and most efficient for them. So we set out our initial thoughts and pared back on what financial institutions would have to do to implement FATCA. So instead of searching through each account and asking each account holder, are you a U.S. citizen, we established a process where the financial institution would conduct an electronic search of its pre-existing accounts and look for certain indicators of U.S. status, things like a U.S. address, that sort of thing, and would only have to follow up where those indicators of U.S. status cropped up. And so restricting that search to electronically searchable files and restricting it to objective indicators of U.S. status rather than to sort of an account-by-account query type situation, I think helped take a step in the right direction of making sure we're trying to balance the burden that FATCA imposes with the compliance goals it's intended to address. The problem, after all of this, is that you can make the process of searching for people as unburdensome as possible, and to the extent there's still an obligation to report on those people or to close accounts, you start running into these legal conflicts with laws in other countries. And that put financial institutions in a very difficult position. Do they join the FATCA regime as participating foreign financial institutions and violate their own country's law, or do they stay consistent with their own country's law and suffer 30% withholding tax on all their income from U.S. sources? Not an easy choice, and I think it's right that there was a possibility people would just decide to pull out investments from the United States. U.S. markets are a hard market to pull entirely out of, just because of their power, but that was a risk, and I think it's worth emphasizing that this was not a risk-free act by Congress when they enacted this statute. They put the U.S. capital markets on the hook as the stick to get people into FATCA, and there was a possibility that people would just dig in their heels and say no. So one of the things that was done during this process was to talk with foreign governments about their concerns about FATCA, and what you saw as the intergovernmental agreement process developed was governments realizing that while FATCA may not have been a popular thing to do, I think no one was thrilled that FATCA came along, it was an opportunity. It was an opportunity for countries to address their own concerns about tax evasion. And one of the things that became clear during this process is that governments in general, who are trying to collect taxes from their residents, have concerns about tax evasion. and needs some way to address it. I think, you know, at its core, tax evasion undermines the integrity of the tax system, and finding some way to limit it and to make sure that governments have a means to address it is something that improves tax administration, helps restore belief in the integrity of tax systems, and make sure that everyone is paying their fair share. And so getting governments on board with that idea, trying to get them to see how FATCA could benefit them, and how it could be a two-way street was, I think, the key to that intergovernmental agreement process. So that was what set the groundwork for entering into these intergovernmental agreements, was setting up foreign governments recognizing that FATCA was there. It wasn't something you could ignore and have go away, and realizing that since they had to deal with it, there was a way to deal with it that would give benefits to their financial institutions in the form of reduced burden with respect to reporting to the U.S., and a way, in many cases, to get reciprocal exchange of information from the United States that would help them address their own tax evasion problems.
I guess I'd like to differentiate between what may be a good idea, that is a worldwide information exchange that's going to benefit each country, which I think Professor Harvey referred to, and really what you're referring to. And then FATCA itself, which again was a unilateral effort by the U.S., and it may have morphed over the last 2 years into more of a worldwide effort, but initially it was simply the U.S.'s effort to obtain information with respect to U.S. tax cheats. And one of the things I wanted to ask the panelists is, focusing just on FATCA itself, do we think it's going to be effective, in fact, in catching U.S. tax cheats? Financial institutions, FFIs, that are subject to these rules will be required to identify U.S. persons. There's a variety of ways they can do that. It looks like probably the most common way that is going to be accomplished is by asking new account owners to execute a U.S. tax form that basically says, I'm not a U.S. person, I'm not subject to U.S. tax, in which case they're sort of off the hook. That's not the only way it can be done, but that may be one of the simplest ways to have that done. If it's a foreign entity that's investing in the bank or the fund or the insurance company, whatever it may be, then there's a requirement in effect to find out who owns that entity that's investing in the bank. And again, presumably that entity will fill out a form that will say it's not controlled by or owned by U.S. persons. So my question really is, you've got U.S. tax cheats, right? That's the premise of FATCA in the first place. These are people who have consistently over a period of years lied on their tax return, right? They're not reporting this income in the first place. They're not saying that they have foreign accounts. They're not doing any of that. And now they're being asked, in order to avoid FATCA, to execute a form that says they're not a U.S. person. So the premise, seems to me, is you've got people who are consistently willing to lie and sign something under penalties of perjury that says I'm not subject to tax, I don't have this income, and now being asked to sign a W-8 that says I'm not a U.S. person, all of a sudden they see the light and say, well, I was happy to lie on 20 forms up till now, but that 21st form, that's just too much. Now I'm going to tell the truth. So is it really going to matter? Is it going to catch U.S. tax cheats? If I want to set up a Cayman Islands entity and invest in a German bank, and I sign a form that says a U.S. person doesn't control that Cayman Islands entity, haven't I accomplished the same cheating that I was able to do more directly before? Maybe it's taken me one more step, but is there really a thought that that's going to keep somebody who really wants to cheat the system from cheating the system? Why don't we start with you, Peter?
Yes. If someone lies over 20 firms, probably he will also over the 21st. But the situation with the 21st and the institution of FATCA is different. Because, yes, it was an unilateral step the US had done. And that's political, not that easy, telling the truth. And the colleagues in the US know that especially. They know that exactly. We have talked and also with the staffers in the Congress before the law was passed, and the international community mentioned all the law restrictions which are in the different countries given, especially data protection law. But with this step the US has gone, we see a different environment in the tax law, in the international tax law. You're right, the compliance costs are really high. It were not fair to say they are not, but the situation is much different because now we have a more successful discussion in the international tax community with several other nations to do more against tax evasion. We have a more deepened discussion, for example, also on OECD level. Someone would probably tell something about that. And we see more interest also in other countries. And especially in Germany, we had in the past 4 years a more political, deepened discussion about the combat against tax avoiding. We have a different situation, for example, with Liechtenstein, which was called an easy point for investors who would like to avoid taxes, or with other countries in the Caribbean and also. And we see worldwide in the Caribbean, we see it also in Asia, we see it also in the Channel Islands, and the development to work closer together. And you have to see FATCA also with in this environment. Sorry for my English, not that good. And you see that FATCA is one part of it all. And so the danger for someone who would lie on the 21st form also is much higher, because the information exchange deepened and will deepen more in future. And this process, this is important, and you have to see FATCA in this situation, not only FATCA as a single law. It's an important step. It is a very expensive step for the companies. It is a step which is also not that easy combined with the law data protection law we see worldwide. For example, in Germany, the data privacy requirements are really high. We have, for example, informational self-determination, which is written in our constitution, and that makes it not easy to forward the data to the US. And therefore we have in the intergovernmental agreement, for example, to make pretty clear the information we send are binded to tax cases and are not usable to other things, whatever. So, but with our commitment to FATCA in the intergovernmental model agreement, and we will sign also a bilateral agreement, we make pretty clear that for this we will go these steps, because we saw so much tax avoidance in the past, and if we wouldn't act as international community, we are pretty sure we would see much more in the future, much more than those guys who lies on the 20 forms would then lie, especially much more on the 21st or 22nd, if it was only a form and there were no bigger and more successful information exchange. But let me say one sentence to you, sir. As I mentioned several times, FATCA is an cost-intensive law for all. That means also for the US tax profits, for the lawyers and also for the IRS. They have to invest in also in their infrastructure. But with the intergovernmental agreement, we hope we reduce the burdens to the companies, to the foreign financial institutions extremely, because they work with their tax authorities. There is no additional need for an agreement with the secretary. Yes, they are deemed compliant. They have to deal with, for example, with the auditing by the German tax officers, and that is pretty clear that that is a system they are familiar with, and also that it is from the technical point easier, but not from the results. So the intergovernmental agreement will help to reduce the costs, but nevertheless, I never would say they are small. They are big. And but it also make it, we hope, makes it more difficult for people to avoid taxes, because we have to go further to several steps, and there is no right for anyone to avoid taxes which are burdened by the legislature in a democratic, transparent process. We have a law which is written by the legislature here in the US and is signed by the President of the United States, and that's what we have to deal with. And that is pretty clear. It's a norm, we say a law, it's a norm, it's a regulation which is based on a democratic process, on the background of situations we don't like to describe anymore, because they were difficult for us and also for Switzerland and other countries.
Jesse, I'm not going to ask you that question, but is this going to, Jim, is this going to fix tax avoidance? Is this going to allow U.S.?
No, I don't think so. And I think one of the things that was missing in this whole process is a cost-benefit analysis to see how much avoidance was out there. And we're not about avoidance, of course, we're talking about evasion. How much would actually be recoverable under this mechanism versus how much is this thing going to cost. Remember, this law does not primarily, there's a new form, of course, for FATCA in addition to the FBAR form, but that does not primarily work by going after the evader himself. It goes by imposing a burden on the financial community, initially the foreign financial community, but as I want to mention, also the domestic financial community. That is, say, you're penalizing somebody through an intensive cost who hasn't done anything wrong.
And
we can say, for example, Switzerland, well, if you want to base your banking system on helping people evade taxes, well, but Germany is not basing its banking system on helping evade taxes. Britain is not. Japan is not. However, they will all be hit with those very intensive costs. And I think, frankly, I'd be very, very surprised if the amount of tax avoidance funds recovered by FATCA anywhere approximates the magnitude of the cost being imposed on industry. It'd be a lot cheaper if we just got all the banks to send a check directly to the Treasury and avoided all the toing and froing. I think the thing, though, that really is politically the time bomb here is that a multilateral enforcement is, in my opinion, absolute necessity if FATCA has a hope of working, and I don't think it's going to work. The downside of that is that it repatriates the costs of FATCA in the sense that, at least in the reciprocal version of the agreement that was pioneered with the joint statement with the 5 EU countries in February, and now has been codified for the first time in the agreement with the United Kingdom, is that American institutions are now going to have to collect data on the residents of foreign countries, reported to the IRS to be transmitted to those countries under the claim of reciprocity, which is important for many countries. I've been told in Germany in particular, but other countries insist that for reasons of their domestic law, that reciprocity of exchange is very important. Now, in fact, if you look at Article 2 of the agreement, it's not really very reciprocal. It's quite asymmetrical in terms of the data that has to be reported. Article 6 commits the United States to eventually achieve true reciprocity, And frankly, I don't think anybody on either side of the table really believes that's going to happen.
Yeah, I want to come back to that.
Yeah, yeah.
I want to come back to that. We'll get to reciprocity in a minute here.
But let me get to the question of cost here. If you look at FATCA as written, the law itself,
Right.
there's not much in there that would impose cost on anybody here in the United States. Suddenly this thing, which was going to impose this magnitude of cost purely on foreign institutions, will now be imposed on American banks, American pension funds, American insurance companies, many of which, particularly non-banks, are really not in any kind of position to comply at all. They don't routinely collect the kind of anti-money laundering and know your client type information that banks do. Plus, they're going to have to start off, one assumes based on the February statement, initially with 5 countries' residents, not just one like these other institutions. These things were not envisioned at all when FATCA was enacted, I would say under less than, let's say, open and thorough debate circumstances in the Congress. I think this thing is, to me as a government relations and congressional specialist, this is a target-rich environment. This is a law that is extremely vulnerable. And the only reason it has not been brought down is that most industry and foreign governments have been so busy preparing to comply with it, they really haven't looked at the possibilities of getting rid of it.
Well, and that's one of the
No.
that's one of the issues that
You're talking to people in Congress does not do it.
that's one of the issues, of course, that came up originally was FATCA imposes these burdens on a bunch of foreigners, right?
Yeah.
What does the U.S. care about a bunch of foreigners? What do we care if foreign banks have to incur billions of dollars of costs, or that they have to go out to their customers and ask each of them whether they're a U.S. person or not, with whatever ramifications that has on customer relations? None of these folks vote, right? So it was easy for the Congress, one can argue, in kind of an overreaction to UBS and the other scandals, to basically say, we need to do something about this. We've got U.S. tax people out there who aren't paying taxes. What should we do? Hey, here's an idea. Let's force foreign financial institutions to have to do all this work for us. Doesn't cost us anything, and we'll get the information one way or another. And so there was a question. You're talking about signing the 21st form? Yeah, I mean, they've already committed a crime. They've signed their tax return and said they didn't have any income. Right? They didn't, going back to the professor's point, and he's probably right about that the principal aspect of tax evasion is probably the more significant thing. The money is being moved overseas, wasn't reported in the first instance. You know, did the statute ever start running? Probably not, because they probably were committing fraud in the first place by signing that form. So asking them to sign the 21st form, yeah, it's one more form, one more obligation that they've violated by signing it fraudulently.
One more risk.
One more risk,
and it's not an insignificant risk. Remember now, their financial institution is checking their certification against the information the financial institution has on file with respect to them that it's collected for anti-money laundering purposes, and financial institutions care about the integrity of that information. There's a pretty broad commitment to the know your customer and anti-money laundering rules. Is it a perfect overlap with the information you need to verify that someone's making a correct tax certification? No, I think that's clear, but it's not a question of a simple bare certification now. There is a backstop of checks, and the amount of verification that a bank must do or a financial institution must do is greater when you're dealing with larger accounts. It's greater for anti-money laundering purposes as well. So, I think it's a little bit misleading to characterize this as just lying on the 21st form after lying on the first 20. The environment is a little bit different post-FATCA than it was before.
And I think that's right, that you do have, at least with the direct account owner, the individual who goes to sets up the bank account in Germany or Switzerland or wherever it may be, that because those banks are already doing the KYC, they know your customer, the anti-money laundering, that person probably is going to be a little reluctant to sign the form. I remain convinced that I could avoid FATCA in 10 minutes by setting up an entity and having the entity set up the bank account, but
Or shift your assets into real estate.
or do other things, right? The people who want to, I guess my fundamental belief in human nature is that people who want to cheat, they're always going to be able to cheat. There's always going to be some way to game the system if you're really interested in doing that. And so I think FATCA is primarily going to catch the people who didn't want to take the extra effort, or sort of the inadvertent folks, right? The guy who lives in Buffalo that has a bank account in Canada because he crosses the border from time to time. It's just easier to have a bank account in Canadian dollars, so when he goes into a store, he can use Canadian dollars to buy it. It'll catch those folks who may not be reporting everything that they're supposed to. Are they cheating? You know, maybe they're cheating. It's sort of on the borderline, I think. But the guy who is smuggling suitcases of cash to Switzerland, I don't think FATCA's going to catch him. That may be my... Yes, sir.
First of all, this agreement is signed, but not in it's not law, because the upper house hasn't accepted it until now. And so we have not that situation, and it's a little bit different, because it's on interest paid, for example, in the Swiss. There's a withhold of 25% plus a solidarity check and so on, and that's it. It's pretty similar. We tax interest income in Germany. So there is no need to go to Switzerland to hide, for example, those interest income in future, because the tax burdens are the same. But in the agreement negotiations with Swiss, Germany has, and that's really a big step for us, and also for the Swiss, it was not easy for their background, constitutional background, and so on. We have negotiated with the Swiss that we receive much more information than in the past and than current. Under the new agreement, we would receive much easier informations. Nowadays, it is not easy to receive any information from the Swiss under the current law. But under the new one, it's compared to the current situation, it's easy, pretty easy. So, and what was the background about this discussion also in Germany? It was a common understanding we have with several other countries in Europe, also with the US, political discussion about FATCA and other ones, that we see that also countries like the Swiss would deal with a stronger, more efficiently information exchange. You're right, FATCA is an extremely burdensome law. No one would say it is not. And it's not only burdensome for foreign companies, it will be under the agreement, if we would sign it so, a reciprocal solution, it will be also burdensome probably for West companies.
Not just probably. I mean,
Yes.
Well, we'll see.
I say probably unless we haven't signed.
We'll see what happens, I guess.
And there is a clear expectation
Yeah.
if we would sign such a paper with the United States of America, that this agreement would live. That mean, there's no doubt, and we wouldn't accept it, but we have no fear that U.S. would deal with their obligations.
Well, let's ask a question about that, though.
Yes.
For example, on the British agreement here,
Yes.
there's a space for the signature. I assume this has been signed. I don't know who the signatories were.
UK is signed, yes.
What is the status of this? Is this an amendment to a tax treaty? What is it's not a treaty itself. What is it?
Before we, just so for the audience, so everyone understands, so we have FATCA. As I indicated earlier, it was impossible for financial institutions in those countries to comply directly. So initially, 5 European countries and the U.S. issue a joint statement saying, we're going to enter into, the U.S. is going to enter into bilateral agreements with each of these countries to implement FATCA basically in a way that allows compliance with local law. And as I indicated, the route the way that's done is the information that FATCA requires, instead of coming to the U.S. directly, is routed through the local taxing authority and then to the U.S. under either an existing tax sharing or information sharing agreement or something new to the extent that's necessary. So that's the so-called intergovernmental agreement, the IGAs that we're talking about here. And the draft IGAs, the model IGAs that were executed, come in 2 flavors, a reciprocal version and a non-reciprocal version. This reciprocal version obligates the U.S. to provide comparable information to the foreign government with respect to their taxpayers. So if there's a German who's investing in the U.S., Germany is expecting under the IGA that the U.S. is going to provide that information to Germany, just as the U.S. is expecting the U.S. account owner that's invested in the German bank to provide to the U.S. As Jim is going to indicate, though, the IGA is a little ambiguous about this. So, Jim, why don't you go ahead and...
Well, no, actually, I was asking Mr. Eggert a question about how this works from a legal authority point of view. For example, this agreement, which is signed by a Treasury official and by an official of the British government, is something. It has some kind of status. But what is it exactly?
It's an executive agreement.
It's an executive agreement, so this does not require advice and consent of the Senate. What about if there were, and the legal authority for issuing the regulations under Article 2 on U.S. domestic institutions comes from where?
Well,
Since it's not in FATCA itself.
Sure. The information required to be reported under Article 2 is consistent with obligations under current law for reporting.
Okay.
So bank deposit interest, for example, there's explicit authority in the code to require reporting with respect to foreign residents. The remainder of the information required to be reported is information that's currently reported on Form 1042-S.
Okay, including for insurance companies and
Yes.
pension funds and so
That's
forth.
right.
And what about under Article 6 of the commitment for full reciprocity? What would be necessary to achieve that?
Well, I guess exactly what is meant by equivalent levels of reciprocal exchange is something that will need to be worked out. And the extent to which there is current regulatory authority to require some of that additional information is, I think, also something that is being worked out. But broadly speaking, what we commit to is to advocate and to support legislation that would provide for, or regulatory action that would provide for achieving equivalent levels of automatic exchange. So it's fundamentally a policy commitment on behalf of the U.S. government to pursue equal levels of exchange with our foreign counterpart. Whether the information we report will be identical in all respects, I think is not completely clear. I think some of the information we're required to collect under FATCA may not be information that's actually useful to tax administration of other governments, and that's something, that I think we'll have to work out as we move towards the push for full reciprocity. But that Article 6 commitment represents a firm commitment on behalf of the administration to pursue equivalent levels of reciprocal information exchange.
So, Jesse, prior to earlier this year, the only information the U.S. was providing with respect to foreign account owners in the U.S., I think this is right, was interest paid by banks to Canadian account owners, correct? Regulations were proposed, I believe in 2010, were finalized in April of this year, that basically changed that rule to apply to all foreign investors in U.S. bank accounts. And maybe you could just describe the political reaction to that proposed regulation on the part of U.S. banks who were now being required to provide information on their foreign account owners.
Sure. Not a popular move, I think it's probably safe to say. And it's important to recognize why it wasn't a popular move. There was some concern, particularly the Florida Bankers Association raised concerns that some of their foreign clients may be in countries where they're at risk of coming into harm if information comes into the hands of the government. The concern is governments in some countries may be less able or less willing to protect the information they're receiving for tax purposes and to use it only for that tax purposes. So the information goes to the tax administration. It might be spread elsewhere in the government. It might leak outside of the government, put people at risk for things like kidnapping, for things like, for coming to harm in a serious physical way and not merely for not being able to evade taxes anymore. And so one of the things we have been taking pains to do is to make clear that our standard for when we will do automatic information exchange with countries has not changed as a result of FATCA. We still take very seriously the need to ensure that other countries with whom we exchange information have the same kinds of protections that we do on tax information, that it may only be used for tax purposes, that there are not just policy decisions on that front, but that as a technical matter and as a systems matter, they keep data safe. And so that has been the way we have tried to respond to those concerns, is to make clear to people, no, we're not going to exchange information with countries that don't take very seriously their obligation to use this information only for tax purposes.
Now, obviously, the Florida banks and in fact both houses of the Florida legislature raised this issue. A more cynical person, I'm not saying there is such a person on this panel, but a more cynical person might have viewed the Florida banks as concerned that perhaps people from, sort of south of the border were investing in the U.S. money that may not be entirely legal in all cases, or that may be investing in the U.S. solely to avoid reporting tax information to their home governments, and that perhaps if the U.S. adopted these rules, it would cause these folks to pull their money out of the Florida banks and put them, in a Cayman bank or some other bank. But that would probably be a more cynical view as to what the banks are concerned about.
Well, it's certainly a difficult point for them to argue.
Yeah. So full reciprocity, if it's done, would require all of this information not just to be supplied by Florida banks and California banks and Texas banks, but every U.S. financial institution with regard to its foreign account owners for the jurisdictions that we're talking about, and maybe it's not all the information that FATCA currently requires, which, as I indicated earlier, is both personal identification information, but also the amount of money in the account, deposits in the account, withdrawals from the account, earnings on the account, all of that. Do we think that in the event that Treasury pushes for full reciprocity, that U.S. financial institutions are going to be happy about that, and that Congress, in fact, will implement it?
Are you illustrating the good lawyer always knowing the answer to the question?
Well,
I think the short answer of no, of course not.
Yeah.
As I mentioned about the cost-benefit ratio with FATCA, this bill did not get the kind of scrubbing it should have gotten in terms of the benefits versus we keep hearing what an unpopular law is. How did an unpopular law get passed? It was not perhaps literally in the dead of night, but it certainly was figuratively when it was included as a less than $1 billion pay for in a jobs bill, did not receive the full standalone death of 1,000 cuts and floor amendments treatment in the Senate that any decent piece of legislation should get. It seems to me that anything that happens from here on out will get that kind of scrutiny. And I would say, given as I say, the repatriation of costs under the IGAs, that's already started. Just to bring to your attention, and you can see this on a website that I run called repealfatca.com. There was a letter written to Secretary Geithner on July 25th, just before the model agreements were released by Treasury from four, as it happens, Republican senators, asking some questions about the cost of this legislation, and plus many other questions as well in detail. Unlike Chairman Bustani, the gentleman in the House keeps asking questions about the bank regulations who can't get any answers from Treasury on his inquiries. These four senators did get a response, which was drafted by a very intelligent and knowledgeable Treasury official, and very adroitly avoids the question of cost, about how much does this thing cost, how much will it impact people.
It was a very polite letter, I thought.
Pardon?
I thought it was a very polite letter, the response letter.
It was a very polite letter. It was a very polite way of not answering the senator's questions. That's not going to wash for the long term. I think this is a problem that's only going to get worse for FATCA over the long term. As I say, I think Treasury is caught, or FATCA is caught, in a catch-22. On the one hand, you can't implement FATCA without the IGAs. With the IGAs, you bring the problem home and turn it into a domestic problem, which it had not been up till now, and that will prove its Achilles heel. I think we have not yet seen, and I think at some point domestic industry will gear up to oppose this. You look at some of the great legislative debacles in the past, like the Catastrophic Coverage Act of 1988 and 1989, or the Dubai Ports World debacle of 2005-2006, something that looks seemingly unassailable, collapses, and collapses very quickly once the inherent flaws in things are pointed out and people are mobilized against it. In fact, one domestic financial industry lobbyist told me that he does not expect FATCA to be around 3 years from now. He expects it to follow the trajectory of the Catastrophic Coverage Act after the thing turns into a horribly expensive international train wreck. Then it'll finally be repealed. And what I would suggest, and that would be the most cost-effective for industry, would be to focus on that outcome now before it turns into an expensive train wreck, when it would be comparatively inexpensive to mobilize opposition to this and get it repealed.
I'll get you in a minute.
I look forward to.
Peter, you want to respond to that?
Yes.
I'll get you in a minute.
I still remember me that in one of the papers from the GCT, I once saw numbers that GCT expect, for example, more revenues through FATCA on this point. So for the budget, for the federal budget, it seems so. That is an interesting point. Secondly, let me mention here one rule we have in Europe between the 27 member states in Europe, and that's the so-called saving direction, and it's law in all 27 countries in European Union and with several other states also. And this direction asks for collection of data pretty similar in some cases, like FATCA, for example, to interest payments of interest. Those countries have to collect those data by their market participants from the TIN, tax identifier number, the address, the name, and in some cases, some countries have a withhold tax, unless I believe 2013, Belgium, for example. UK is not that happy, but deal with the directive. It's a current law, and it works pretty well. This isn't really big institutional information exchange. We have that. And it works full automatically. My colleagues in the Federal Central Tax Office in Bonn deals with this law since years, really successful. And so, and that's important, those guys can't so far avoid their taxes, so far. You never will see that you have a tax environment worldwide that is not possible to avoid tax. I'm pretty clear. But for example, this was an important step in Europe for us. So to exchange this information, and it works really good. There are some problems. I don't like to say that everything is 100%, but it works really efficiently until now. It could be better. Everything could be better, but it works. And it's an information exchange on automatic way with the internet, via the IT environment. That works. And on the long run, we expect that would happen also with FATCA. The big issue on the burdens you mentioned is to deal with the old accounts, with accounts which are there when FATCA starts, not for the new accounts. The new accounts, it's pretty easy. You have a customer come in a bank and would like to open an account, for example, in Cologne, US. The customer would come and the banking officer would ask him for his address and if there is a connection to the US and standing or order address and all this kind of things. That was pretty easy. The problem is to introduce FATCA for the old accounts and for also for the old obligations, grandfathering clause. That are big issues, and therefore, and that would be also probably in an intergovernmental agreement in the long term for some US banks a problem. But I'm pretty sure we would be able to deal with it. But our expectation is when we would sign such an agreement, that it will live on both sides, no doubt.
Yeah.
And a diplomatic agreement, which would be in line with 26 of our double agreement, tax agreement, we would expect there is no gap. But we would expect it would full live on both sides. We would do everything we can, and it's pretty clear our expectation to the US were the same, but we were sure that the US would deal with that. We have no bad experience, no, nevertheless, we have only good ones, and so we can deal with it. But it wasn't, and that's important, it was a decision by your parliament, and I'm fully aware that all the members in the Congress which say yes, I'd like to see FATCA, and if they vote for it, were awakened in the situation. And that were awakened in the situation, and they know exactly what they have done. I'm pretty sure, believe me, the international...
You have a higher opinion of them than...
No, believe me,
How many people here have experience in Congress?
Because the members of your parliament were very informed by the international banking community, insurance community, also by the diplomatic community. They had the chance to receive that and to use those information. And so we think it was a clear decision by your parliament that we can deal and that we do deal with.
Carol, you had a question? I guess the point, though, Carol, is that certainly on an executive level basis, this is seen as more part of a worldwide or bilateral approach. But I think it's quite clear that Congress, at least when FATCA was presented to it, was not drafted to be a reciprocal sort of arrangement. It was a very one-sided, one-direction sort of arrangement. And I mean, it's interesting, you know, I don't doubt that Treasury is committed to proceeding on a reciprocal basis and proceeding to get statutory regulatory authority to provide information within the context of full reciprocity. But I think Jim's point is very well taken, that at some point, U.S. financial institutions are going to wake up to the fact that if it is reciprocal, or at least more fully reciprocal, that it's going to involve a lot of costs on their part. And I think when you read the letter from the Republican senators who wrote to Treasury, that it has a very strong tone to it that, wait a second, we're not sure we're really fully invested in this thing on a bilateral basis. We want to know how you can agree to do this, what your authority is, what you're going to need in order to implement it, what it's going to cost, all of that. And Jim's exactly right that the Treasury letter, although very polite in response, didn't really address those questions. And so it's going to be interesting to see what happens. And I guess my question for you, Peter, is let's assume, notwithstanding Treasury's efforts, that they go to Congress and Congress says, you know, we've looked at this and we're perfectly happy for this being a one-way sort of street. And we're not going to pass legislation that forces U.S. financial institutions to incur costs. What's going to be the response to the IGA partners who have signed these agreements with the expectation that the U.S. was going to join hands?
It's not that I have no understanding for your critic on this. It's, I fully, if I were you, probably I would argue the same way.
Well, you can take the conditional out and disagree on that.
As I mentioned, I have done it hopefully diplomatic enough. It was not easy to understand FATCA also from the economic point of view and from the political point of view. And my first word was wow. And that indicates that it had an international aspect. Yes, that's pretty clear. I'm not naive. On all partners which discuss with the United States of America, a wonderful, great land, a country to be here is wonderful every day. I'm not naive. They are not. No one. Believe me. And we are adults enough to see what is possible and what not. But we see also the current law in the IRS code. And the IRS code, you mentioned it a few minutes ago, gives the authorities here the right to have an information exchange currently with Canada. And as my distinguished colleague from the Treasury mentioned, it is discussed also have an exchange in this way with other countries, like us, when we have an intergovernmental agreement. And our wonderful experience with this country is that we are sure if once this country committed to something, if once this country promised something to do, it does it. Because it does it, believe me. For me as Germany, the country which was divided 22 years, 23 years ago, we are now reunified because the US were committed to their promise to do everything to overcome the division of Europe. And that's our deep common understanding that we have such a fair partner here that we find a solution which gives both sides the possibility to deal with it and the hope that we will be fair together. That means I'm much more optimistic than probably you that sometimes the US Parliament will give the IRS the possibility to work also in this part more sufficient than now, but now they are really also sufficient because we have a good information exchange under the current treaty, and we will make it more effective. So my hope is not that we see a situation on the wrong one. No, there will be no change in the law. I'm optimistic, and if I were not, I would not sit here, believe me. It's a long way, and it's a really difficult discussion, and it's a political discussion, and it's an economic discussion. To do everything what is from the burden possible to reduce the possibility to avoid taxes is from, I'm an economic person, is from the economic point of view much more important than to do nothing, because someone who avoids taxes has an unfair competitiveness situation than the other one who pays fair share of taxes. So we have, from the economic point of view, as international community, to do everything that's needed to be more successful in this area, from the economic point of view. And I'm sure I'm here in a country which the economic point of views are very often as well important as foreign situations.
So Jesse, you just have the obligation to uphold the honor of the U.S. with respect to coming up. Yeah, Richard.
I guess let me make a comment and then maybe a question for Mr. Jatras. I guess the comment is, I've been in the tax business for almost 40 years now, and most every time additional information reporting is required in the law, whoever has to do it ends up screaming bloody murder. So I think part of what's going on here is sort of a natural reaction, given their druthers, financial institutions, both U.S. and foreign, would prefer not to do financial reporting if they could avoid it. So I think one of the things one has to look at is, okay, there's that initial screening, initial cost. The question is, once you get in a steady state, whenever that is, whether it's 3 years, 5 years, 10 years, is that steady state a better state than what we're in right now? So that's a comment. I guess my question, obviously, I hadn't heard of appealfactor.com, I'll have to look at it. Interesting website. But I guess my question is, do you believe, Mr. Jatras, that taxpayers should be allowed to evade taxes through offshore accounts? And if your answer is yes, then okay, I understand where you're coming from. If on the other hand your answer is no, they shouldn't be allowed to evade it, then I guess what would be your alternative solution to FATCA?
I think the short answer would be, actually reminds me of your question to the Swiss institutions. Do you think you should be able to base your banking system on helping people avoid taxes? And of course not. And the answer is, of course not as well. I don't think people should be allowed to evade taxes. They can certainly avoid them legally, but they can't evade them. I think, however, the short answer to what's the alternative to FATCA would be something else. Something that actually pursues the evader rather than puts a burden on a lot of people who haven't done anything wrong. I agree with you about this steady state, that once, say, 2-3 years from now, we've gotten to a steady state where, let's say, 30 countries have signed IGAs with the United States. At that point, FATCA may turn into the matrix will start coming into being. That will be self-sustaining at that point. I asked the other question, which is, what if that doesn't happen? What if it's possible through legislative means to prevent that coming into being, since I think IGAs are an absolute necessity for FATCA's workability, and that's why I do think Treasury is in a race against time, and to sew up as many of these IGAs as possible before a repeal effort gets established and under a head of steam here, because I think if that were to occur before more than a handful of IGAs are concluded, we don't get into that steady state and FATCA collapses. Now, I do believe if that were to happen through the legislative process, we would, in the course of that, identify what might be, perhaps be a better model for actually chasing the bad actor, rather than imposing costs on everybody and sundry around the world in the hopes that we'll catch some bad actors in the process. And one footnote to what Peter said about talking to the Americans. I don't think it's sufficiently appreciated in the foreign community that we don't have a parliamentary system, that when the Treasury Department speaks, they don't represent a legislative majority in the parliamentary sense, but rather they're an executive branch agency whose job is to enforce the law. Congress, in its infinite wisdom, passed a law. Here it is, go enforce it. And I think they've done a very good job with what they were given, but that doesn't necessarily reflect a continuing political commitment by the United States to do something. As recently as 3 months ago, I talked to the chief of staff of a senator on the Finance Committee who had never heard of FATCA. And he was not an ignorant person. He's actually a well-informed person. He's not committee staff. He's a personal office staff. It's amazing once you get outside of the community of accountants and tax lawyers who, and no offense to accountants and tax lawyers, who hope to retire and send their kids to school on FATCA, you find a shocking degree of having heard of FATCA at all, and you say, well, what is FATCA? What's this law that does this? You're kidding. Oh, and not only that, they're going to have these agreements that will oppose the same requirements on American institutions so they can report to London, Berlin, Paris, and so forth. You're kidding. This thing doesn't pass the laugh test when you actually get onto the ground politically on the thing. If the thing had not sailed through as part of a pay for in a jobs bill, this thing would not have been enacted, and I think it is extremely vulnerable.
I think probably worth saying a couple of things about, I guess, the various things we've been talking about over the last few minutes. First, I don't think anyone would argue that FATCA is a perfect statute. That certainly doesn't pass the laugh test. There are some issues with implementation. IGAs were intended to address some of those issues, and I think no amount of discretion in implementation is going to make FATCA perfect. But there has been a dearth of suggestions for workable alternatives that would achieve the same goal, the goal of helping prevent tax evasion. And I'm not sure how easy it is, and this is just me speaking off the cuff. I am certainly not an expert, but how easy it is as a political matter to say, let's get rid of the law designed to prevent tax evasion without any alternative, without looking an awful lot like you're coming out in favor of tax evasion. So I'm not sure it's politically a simple thing to just say, let's get rid of FATCA. As far as the cost-benefit analysis question, I think that's it's a question I'm always a little amused when I get when members of Congress raise questions like, have you done a cost-benefit analysis for FATCA? And I look at it and I say, well, my job is to implement the law that you passed. Probably the time to do that cost-benefit analysis was when you were thinking about passing it, and not afterward when you're asking me to enforce it. And there's a limit to how much we, as an executive branch institution, can do to make FATCA just go away. We're given a law, we have to implement it in a way that's reasonably consistent with legislative intent. And I think there's no way for that to impose no cost on financial institutions.
Yeah, but hang on a second, Jesse. That's true as far as FATCA itself, but Congress did not enact the reciprocal scheme or the reporting burden on domestic institutions. That's something Treasury came up with, and before doing that, shouldn't Treasury have estimated the cost of that?
I think one thing to keep in mind in that context is, I think your earlier statements are probably right, that without intergovernmental agreement, implementing FATCA was going to be very difficult, was going to be extremely burdensome, was going to require the imposition of withholding tax, which was never its goal. Its goal was not to collect withholding tax on foreign financial institutions. It was to encourage compliance. And to the extent that it is impossible for a foreign financial institution anywhere to comply with FATCA as written, there needs to be some way to make it possible. And intergovernmental agreements are the way that address the concern over conflict with local laws that would have prevented FATCA from being possible to be implemented. Taking that step and realizing that has to happen, it's also, I think, pretty straightforward to realize foreign governments are, with their own tax systems to enforce, are going to have a tough time agreeing to enforce U.S. tax laws without getting something reciprocal. That's not to say they don't get any benefit under the IGAs. If they don't get reciprocal information exchange from the United States, they do. The intergovernmental agreements represent a pretty significant simplification in the application of FATCA for their financial institutions, and that shouldn't be understated. But it's difficult for the United States to say, yes, please collect all of this information about U.S. people and send it to us, but no, we won't collect any information for you to help you administer your tax laws. I think that's, again, something that's hard to get past the laugh test on.
Jesse, we have only a few minutes left. Obviously, we've talked about FATCA being a unilateral effort by the U.S., but the rest of the world was not sitting completely in the dark with regard to information exchange. And I think if you could maybe describe the OECD's efforts and the trace system and sort of where you see that going and where you see it going in relation to FATCA itself, it might be helpful.
Yeah, sure. So I guess probably a couple of things to talk about there. The first is that Working Party 10 at the OECD, which is a relatively newly constituted body, formerly Working Party 8 for anyone who cares, it deals with questions of information exchange. So it deals with interpreting the information exchange provisions of our treaties. It deals with the multilateral convention for the exchange of information and administrative assistance. It deals with implementation of tax information exchange agreements under the OECD model. And they have had discussion about multilateral information exchange for quite some time. I think the passage of FATCA has significantly advanced that conversation as people realize that while FATCA may not have been the solution they would have designed, it does put pressure on actually working towards real multilateral information exchange solutions. So there has been work in that context going on in the OECD. The TRACE program is sort of a little bit of a different story. A number of years ago, there was a project called the CIV project, Collective Investment Vehicles, that is trying to deal with the problem that collective investment vehicles, particularly those vehicles that invest through tiered structures, where there might be multiple levels of entities involved in the chain of payments, have a tough time getting treaty benefits because they might be a transparent entity and might need to be able to prove who their owners are, which in the case of a widely held collective investment vehicle may be difficult. B, multiple tiers lead to documentation problems. So how does the first person making a payment to a lower tier entity know who's behind the entity 5 tiers back? And so the CIV project created a set of policy level rules about how CIVs should be treated as getting benefits and led to a group called the TRACE group. And I can never remember what TRACE stands for, Treaty Relief and Compliance Enforcement, I think, meant to deal with some of the technical issues with getting treaty benefits. And so what TRACE contemplated was that it should be relatively easy for foreigners to get benefits from a source country with respect to payments. And in order to make it easy, the TRACE project contemplated reporting of information about the recipients of payments to the source country. Once that reporting to the source country happened, that information would now be in the possession of the source country and could be exchanged with the residence country, and in various, it's not, I think, completely clear how the TRACE project will go forward on that front, whether it will contemplate automatic exchange to the residence country or whether it will simply be added to the sort of collective information that a source country has and can exchange on request, but it did sort of contemplate a collection of information and a transfer to a source country. FATCA was looking at a different problem. FATCA was looking primarily at collection by a residence country of information about its own residents. So the two were directed at not completely distinct, but different goals. So instinctively, it's not clear how much overlap the two would have, but there was a lot of work done during the course of the TRACE project about format for information to be collected, about how that transfer of information should happen, about how to collect information in a format that would be workable on a multilateral basis. And that process is something that's going to be very useful, I think, in developing a bilateral or multilateral solution for FATCA purposes. It would be a shame to waste, to try to reinvent the wheel on information exchange. And so I think it's probably easiest to say the two programs, FATCA and the TRACE group, aren't really directed at the same goal, but there's a lot of learning behind the TRACE project that I think can be valuable to help make FATCA information exchange work efficiently.
And I think whatever else you can say about FATCA, it has accelerated the discussions with regard to information exchange on a worldwide basis. And so, although it can be argued that the U.S., maybe this wasn't the finest effort of Congress to start down this path, and it's certainly an understatement to say FATCA is a well-drafted statute. I think Treasury should get a lot of credit, although we've given them a lot of grief about this, in trying to implement something which was almost impossible to implement. On a long-term basis, there is going to be much more information exchange on a going forward basis. Whether it's under the rubric of FATCA or not, I think is open to question. We're actually over our time slightly, but if you've got any questions, we'd be happy to entertain them. And otherwise, we'll let you go get some coffee, I guess. Thank you very much.